Welcome to U.S. Immigration TV. In this video, I will discuss the various options and choices a person has when their case is denied. So make sure to watch this video until the end, and of course, like, share, and subscribe to this channel. Now, I know that when a person's immigration case is denied, it can be one of the most tragic, heartbreaking, and depressing times in their lives. They wanted to legalize their status in the U.S., perhaps bring their family over and live the American dream. But a denial crushes those dreams. If your case is denied, is there anything you can do? Is there hope? May you reapply? Well, quite honestly, there's no clear black and white yes or no answer, as there are many factors that have to be taken into consideration in evaluating what to do with the denial and if there is hope. I would advise that you should consult with an attorney who can guide you in terms of evaluating what to do if the case is denied, and whether it's best to appeal, refile, file a new petition or application, or maybe a motion to reopen or motion to reconsider. Now, here are some of the factors that a person would have to take into consideration in evaluating the next step when they receive a denial. Number one, why was the case denied? In order to determine if there's hope on a person's case, of course, it's first important to determine why their case was denied. In fact, in some situations, a person may not be eligible for any immigration benefit, or they could possibly get themselves into deeper trouble if they keep filing. For example, if a person was denied because they confessed they were in a fixed marriage, that usually results in a lifetime ban and no future petition by anyone else, such as a new spouse or an adult U.S. citizen child, can be approved. Similarly, if a person had claimed to be a U.S. citizen, or they registered to vote or voted in a U.S. election, there usually are no waivers available, and it's unlikely their case will ever be approved. On the other hand, cases or waivers may have been denied because not enough proof or evidence was submitted. In those cases, there could possibly be hope, perhaps by submitting additional evidence or documentation. Number two, are there deadlines? Now, when a case is denied, there are usually time limits, typically 30 days, 33 days, to file an appeal or a motion to reopen or a motion to reconsider. If you have received a denial, but you wait years before doing anything about it or consulting an attorney, the deadline may have passed. And if you try to file a late motion, USCIS may deny it without even bothering to read it, simply on the grounds that it was untimely. Number three, appeal or refile? Well, depending on the circumstances of the individual case, it could sometimes be more advantageous to refile a new petition or application than to file an appeal. By appealing, the person is usually restricted to the evidence of record, meaning the documents and evidence they already submitted. And they have to argue that it was sufficient and the officer denying the case made a mistake. But what if they did not provide enough evidence or documents? Well, their chances of winning the appeal decreases. Now, with a new filing, the person could provide new, additional, and stronger evidence to support their entitlement to the immigration benefit they seek. In other words, new evidence is allowed if you refile. Also, in certain circumstances in refiling, the person can get a work authorization, which could not be possible if the case is on appeal. Also, in some cases, it could actually be faster to file a new case than to wait for the outcome of an appeal. However, this is important, before making any decision of whether to appeal or refile, you should consult with an attorney, because there are many other factors to take into account, such as the effect of a new filing on a person's immigration status, and in certain circumstances, they may be required to appeal to hold on to the original filing date. Number four, do you now have stronger or better evidence? Now, there are some filings, such as fraud waivers or provisional waivers, where it is required that the person demonstrate extreme hardship on certain relatives, such as their U.S. citizen or lawful permanent resident spouse or parents. Now, it could be at the time you originally filed your waiver, there was not much evidence of extreme hardship and the case was denied. Well, before refiling, you have to examine whether there is new or additional evidence that can be presented to greatly increase your chances of success. Or maybe with the original hardship waiver package, the case was not fully or properly presented or explained. In fact, I've had many cases where people have come to me with a denied waiver and there really was not much evidence. The declarations were not compelling or convincing. Now, it's important to know that just because a person's case is denied does not necessarily mean there's no more hope and the case is over, your world is crushed. Maybe there is hope. And that's why I would recommend that if your case is denied, you consult with an attorney who can evaluate what is the best next step and if and when you should appeal, refile, or perhaps leave it alone. But I want to be clear that no attorney can guarantee success, but an attorney can better evaluate your options and chances. And I would, of course, recommend that before you even initially file, you should have consulted with an attorney to help you evaluate and package your case rather than first trying to do it on your own, getting a denial because it was not properly packaged or presented, and now you go to an attorney with a denial. Well, I hope you have found this video informative and helpful for you in case you get a denial and the factors that need to be taken into account. And if you know of anyone else who has received a denial, please share this video with them, as well as like and subscribe to this channel. I'm Michael Gurfinkel, and thank you for watching U.S. Immigration TV.